Three, two. Hey there, everybody. Welcome back to G&G Live, the edition of G&G Law, where we open our virtual doors to you, our internet audience, and take your questions and comments and talk to you about some of the more nuanced topics in the legal world that maybe you're not aware of, or maybe you are, but you want more information about. That's why we're here. I am joined today by two fabulous guests. One is the mainstay of G&G Live, our founder and owner, Michelle Green, and the other is a trademark attorney who we started working with to help our clients through the application process, Michael Reed. He is phenomenal. He's such a rock star in the trademark world. He runs his own firm. We're working with him to, again, help our own clients with that as well. And we're really excited to have him on. Our talk today is going to be about trademarks, which is why we asked Michael to join us. It's going to be specifically about office actions, which are letters issued by the trademark office. We'll get more into that, but that can, block your way to registration if you're not quite sure how to deal with it. And I'm not going to say too much more. We're just going to dive right in. But before we do, of course, quick disclaimer, this is not legal advice. This is for informational purposes only. It's not tailored to you or your business. If you would like information that is tailored to you and your business, feel free to reach out. You can do that on Facebook right now. You can do that on our website, contact page, email, phone. We got all the channels, so feel free to get in touch. Without further ado, I'm going to bow out, and we're going to get this party started.
Right. Thanks, Ian, so much. Always great at this. Good intro. And thank you so much, Michael, for coming on board and being part of the G&G Law team. It's great to have another super experienced trademark attorney so we can expand our trademark practice and help even more clients. And it's great to have you here, too, to talk to everybody about office actions.
Thank you. Thank you, Michelle. Thank you for having me. And it's a pleasure working with you to assist people in navigating the trademark application process and making sure that that the name that they're chosen for their business, the logo, or related phrases are protected and useful in denoting the source of the services and goods that they offer.
Yeah, it's such a key part of people's business is the names and the logo that goes with it and their associated phrases, and so we're happy to help people protect them. Glad you're here to help us.
Absolutely.
So talking about office actions today, which maybe is not the most fun part of the trademark registration process. Ian did a fantastic job. I tasked him with, we need a picture of a roadblock. And I love this elephant in the path representation of office actions, and that's how I'm going to think of office actions now. So we can think of office actions as roadblocks to getting your trademark registered. And sometimes it's a roadblock or an elephant that you can expect and easily go over it or around it or get your elephant in the path to move out of the way. But sometimes you get an office action and you need to find a new path. So Michael is going to tell us a little bit more about those differing situations. And he's going to answer some of the most commonly asked questions that we get about office actions. So here we go. Maybe. I can't get this slide. This happened before too.
Well, that is a very pretty elephant.
It is a very pretty elephant.
Maybe we can just jump into it and we can have the elephant there to contemplate while we talk about office actions. Oh, here we go. First slide. So what is
an office action by elephant?
Well, as implied by the previous image, an office action is a stopping point in the road to receiving your trademark registration. It is a letter that you receive from the attorney that your trademark application has been assigned to, informing you that there are some issues with your application that need to be addressed before it will be continue to be processed and move along the road to registration. There are a number of reasons that that the examining attorney could issue a office action to you, but there are really only two kinds. There are non-final and final office actions, and usually you get a non-final before you get a final. Now, what a non-final office action is a request from the examining attorney to address certain legal issues that they've spotted within your application. Now, this can be something as simple as disclaiming certain words that you have stated that you want to claim rights over in connection to the goods and services that you offer, or it can be something more serious, as in an event where a trademark already exists or is already in process that is very similar to the one that you are seeking to register, and therefore the examining attorney sees there being a likelihood of confusion. Meaning that if your mark was registered and this other mark was registered, that there is a likelihood that consumers will be confused as to which mark belongs to who and which mark belongs to which services, which mark is a designation of source for which goods and services and who provides those goods and services. Now, the first type of office action, variety of non-final office action that I mentioned, where the examining attorney is simply asking you to disclaim certain words or phrases that are a part of your application, is usually pretty easy to handle. This is something that you will be notified of in the letter that you receive from the examining attorney. They will ask you to disclaim certain aspects of the word or phrase that you're looking to register, such as, by way of example, if you were to register.
I was talking about this with Rebecca because we filed the trademark for G&G Law. And when we filed it, we were like, okay, we're going to have to disclaim the word law eventually, because you can't get a trademark for the word law because it's type of office. It's descriptive, right?
Mm-hmm.
And then we filed the trademark. We didn't disclaim it right away, which is typical. It's part of the strategy. And then we could have gotten an office action back, and it would have been totally expected and easy to deal with instead of as an examiner's amendment, but a similar type of action for disclaiming the word. So yeah,
yes,
makes sense.
Yes.
So that was disclaiming.
Mm-hmm. Yeah.
And you're hopping into the different types of office actions, which is great.
Sorry. Yeah, I was maybe getting a little ahead of our process here. But that's a really good example, and that's something that you should expect when you file a trademark application, is that unless you are disclaiming certain words or parts of the phrase that you're looking to register from the get-go, you're probably going to get some pushback from the examining attorney. The example that Michelle gave of her own law office seeking a trademark is a good one because, as she mentioned, the word law is descriptive, and we don't want to, it is descriptive of the actual services that she's providing. It really giving her exclusive rights to the word law as pertaining to the services that she's offering would prevent essentially anyone else who is in a similar field or has the word law in their name from providing those same services. So of course the office, in the public's interest and in the interest of consumers, is going to push back on a registration or on an application that seeks registration for term or for a phrase that includes descriptive terms such as law. Something else that you may run into with these types of office actions is the fact that that words translated into other languages are not necessarily distinct from each other. So you could have a t-shirt company called Elgato, and if another t-shirt company already exists called The Cat, that could cause a problem for you through the registration process. You would definitely get an office action back, and the examining attorney would certainly be asking you to distinguish your products or the services that you offer from the goods and services offered by the other company, even though your name is not technically the same as theirs, one being in Spanish, the other in English. Uh,
There's
they
still
are
that likelihood of confusion.
there's still the likelihood of confusion. They are still too close, too similar, too likely to cause confusion in the mind of consumers and in the public interest, something that the examining attorney is going to need to push back on you for.
Yeah, so that's
Mhm.
great. So a few of the common types of office actions are because the mark is descriptive or because the mark causes a likelihood of confusion with other trademarks already registered. Any other super common types that you see over and over again that we should mention?
Those are really the main ones. There are like a number of smaller uh, responses that an office that you may need to. There are some different sort of folds to responding to an office action that may come up. It may end up that you just respond through a web forum, disclaiming certain words as directed by the examining attorney, or you may need to have a conversation with the examining attorney, find out what what they believe the basis for a refusal is. They will give you a detailed description based on the law, in the letter that you receive, but it always pays to reach out to them to get to make sure that you're understanding their objection properly. And when I say you, I mean your attorney, because when you get an office action, that is when you want to get an attorney involved. Because as I mentioned before, there are really only two kinds: there are non-final and final. And non-final, you get one chance to respond, and if you don't raise any new legal issues, and the examining attorney is not satisfied with your response, you will receive a final office action, which is much harder to deal with, and that is your final shot to overcome the examining attorney's objections to the registration of your mark. And if you fail, your application will be prevented from
Okay,
proceeding to
that's a
registration.
really good point. So two main types of office actions, non-final, final. And if I'm somebody who owns a business and I'm like, I can get this trademark myself, I'm going to file my own trademark registration, I don't need a lawyer. A non-final office action does not mean you get one chance to try for yourself and then you can get the lawyer on the final office action, right? There's certain arguments that you have to get out at the non-final office action or you lose them.
That's exactly right. And you usually have a 6-month window from the issuing of the office action, from receiving the letter from the examining attorney to resolve any legal issues that they've identified with your application. And that is a good window of time to find an attorney to assist you with your application at that
It's
point.
possible.
And the sooner the better. Really, you want to give an attorney that full 6 months to
Yeah.
respond. So if you can find somebody within a couple of days to a week, that's ideal. Even 4 months is cutting it close, especially if there is an objection to the samples that you've provided in your application. It may take some time to come up with to produce samples that will be acceptable to the examining attorney in demonstrating the services that you offer, the goods that you provide, and you want to give yourself some leeway. You don't want to be rushing to get your application in. It's more stress for you, and if something goes wrong, it's less likely that you'll have time to correct your mistakes before your response to the office action is
Yeah.
submitted to the examining attorney.
So the answer to what should you do if you receive an office action? Step one, reach out to an attorney as soon as possible. This is not the point where you should be responding on your own. And then maybe is there a step 2 of every time somebody reaches out to you and says, here, I have this office action, then you, Michael, say, okay, I will respond to this office action for you.
Yeah, so there is usually a back and forth between myself and the examining attorney once I'm brought on to handle an office action. Um, Unless it's something very simple, where, like I said, I just go onto the USPTO's website and, I disclaim the word law and, as in the example that Michelle gave, or any other, words the, um, that the applicant had included in the phrase that they're seeking for registration that would otherwise, be descriptive and, and if allowed to be registered, would otherwise bar people who are providing similar goods and services from seeking a mark or from providing those goods and services to consumers. Um, Usually, if it goes beyond that, if it is a more substantial objection on the part of the examining attorney, there is usually a little bit of a back and forth. Usually, have a couple of emails with them, make sure that we have a clear understanding on both our sides as to not only what the office action, what the objection is, in their mind, but how they would like us to resolve it. And then once that process is done, once that conversation has been had, then I work with either the applicant or the examining attorney to make sure that all the materials are assembled for the response, and then submit the response. So it's really sort of a 3-part process.
Yeah.
1, consultation with the applicant. 2, conversation with the examining attorney. 3, preparation of the application and submission.
What happens if during the consultation with the applicant and you look into it, you're like, this is never going to get registered? We had done a comprehensive search at the beginning. We would have known this office action was coming, and you could respond, but you don't think you're going to win.
Yeah, so at that point, that does happen. That does happen. At that point, the conversation is not how do we respond to this, but it is potentially a harder conversation. Yeah, where I have to talk with the applicant about abandoning their application because, especially in the case of a 2D refusal, 2D refusal means that there is a substantial likelihood of consumer confusion, that the examining attorney has found a mark in the trademark database, either for an application that is in process and has a priority date, or that is already registered that is identical to the one that the applicant is seeking to register for themselves. In that case, that application is not going to get through. They would either need to be offering very, very different services and goods, and we would need to demonstrate the fact that these services and goods are different to the examining attorney, or otherwise, any response that I would give to the examining attorney would be rejected and would move us to a final notice of refusal. Which in the case of likely consumer confusion of a 2D refusal, a final refusal is possible. You may get a final refusal immediately from the examining attorney. They may not allow you to move forward at all, without some Herculean effort on the part of you or your attorney.
And then is it worth it if you're a small business owner on a budget? And sometimes these conversations are hard, but we have to have these kinds of conversations with clients all the time. Sometimes the elephant on the path is too big and too stubborn and not going to move. And you have to think about, did you find another path? Is it time to think about changing the name for your business before investing too much in this name? Just move on and choose something else is sort of the strategy behind it. And those are hard conversations to have as an attorney. Interested to hear what you think about it, but they're also it's still gratifying to be able to go through that strategic process, I think, with clients and say, here are all your options. Let me help you how to decide what the best path forward is.
Yeah, I would agree. Yeah, they're hard conversations, but ultimately they're in the best interest of the business owner and their business.
Yeah. Sometimes if you know you're going to have to change and pick a different path, the sooner the better. That's what saves you the most
Absolutely.
money. I don't know if your clients are interested in saving the most money, but
Mine usually are. Mine
yeah.
usually are. Yeah, sometimes it's not better. Sometimes you can't move the elephant. Sometimes you just find a path.
So we talked about this a little, the process and timeline for responding. You mentioned that there's 6 months to respond. Is there more to the process?
Yeah,
Did
so
we cover it?
usually, so six months is the window, standard window for responding to an office action. If you need to extend it, you can usually get a 3 month extension, but after that, that's barring extraordinary circumstances, the government is not going to allow you to extend it beyond that. So you really do want to make sure that you're able to respond appropriately to an office action within that initial first 6 months. That's the most amount of time that you're going to get to respond to it, and that's the most amount of time that you're going to have to, converse with the examining attorney, make sure that you get everything together and that you know what the strategy is for responding. And yeah, like if you end up having to submit a request for an extension, it may get denied. So you don't want to rely on that.
Yeah, and so people out there know too, a response to an office action is not like a form that you find and you check 3 boxes. It involves research and crafting arguments and writing and maybe attaching evidence, but you would call it samples or supplements, I think. But
Yeah, I usually describe it as evidence, but yeah, just photos or digital images that or other things that you can transmit over the internet to the government, to the examining attorney, that demonstrate the fact that you're using your mark in the way that you claim you are, in connection with the services and the goods that that you actually offer to consumers. And part of an office action may be actually the examining attorney saying, no, you don't. I don't believe you. I don't believe you that you offer the services that you say you do. And they may ask you to either prove the fact that you are offering the services that you claim under the mark, or to amend the service description in the application.
makes sense. Yeah, there's a lot of argument crafting that goes into drafting the office action and providing evidence and writing out the legal arguments.
Absolutely.
All right. We touched on this a little bit too, but how can you avoid an office action?
Well, the best way is to make sure that you know what is coming. Like the best way to avoid an office action, you may not be able to avoid one entirely, but you can at least know when to anticipate it and what you need to do to get around it. It's all about strategy. It really comes down to the strategy. If you know that the elephant is going to be in the road at certain times a day, you just have to plan around that. And things that you can do to accomplish that is hire an attorney who understands this process, such as Michelle or myself. Another thing that you can do, or through your attorney, is order a comprehensive search of the USPTO's database, the World Wide Web of court filings related to trademarks, and that way you'll know whether or not there is a mark out there that's similar to the one that you're seeking to register.
Totally. Yeah, the best, and what we recommend for pretty much every client before we apply for trademark registration for that client is do the comprehensive search first. So we can know what the likelihood of success is going to be of this application. Uh, and it's kind of astounding to me how right we are based on that comprehensive search. I can't say 100% of the time because we're lawyers and we don't say that, but pretty close. But that's the way that you save the time, the energy, the money, is take the time and money and energy up front to do a full search to know what you're getting into. And then almost always we can predict which office actions are coming, if any, whether they're easily deal-withable, whether they're easy to deal with, or whether it's time to talk about, okay, you might need to think about a different path.
Absolutely, absolutely. It's all about strategy and anticipating where the roadblocks are going to crop up.
Yep. So office action fees. This is kind of a tough question because, as we've been discussing, office action responses vary in how much time they take and how complicated they are and how likely they are to succeed. The G&G law fees for, we have a flat fee process for trademarks. Our flat fees for a simple trademark application for registration is $1,100 plus government fees. And that fee includes responses to simple office actions. So you don't need to worry about, like our example of if the examiner comes back and says you need to disclaim this word because it's descriptive. That's included in our flat fee. But if we get a client who didn't retain us at the application for registration stage and they did it themselves and then they get an office action back, that's a little bit more complicated to deal with because it often takes more time to unravel what somebody else did than it would take for us to just start from the beginning and do it. So, there's simple office actions to more complicated office actions, and our flat fee is dependent on whether it's simple or complicated. So it ranges from something like $1,300 to $3,300 to respond to an office action. And then, Michael, we were talking a little bit before the live stream that sometimes there might be USPTO, which is the U.S. Patent and Trademark Office, the government agency that covers trademarks. They sometimes have fees, but not always. Responses, right?
Yes, that's true. In most office actions, you're not going to be required to pay an additional fee to respond. The government wants you to respond. They want to move this process forward, or they want to, know whether or not, this is going to be a registrable trademark within that first 6 months. So they want to give you the opportunity to respond. There's really they're not going to disincentivize you responding by charging you an additional fee at that point, at least for a non-final office action. There may be situations where fees will apply, and in those types of situations, they're usually pretty nominal. It's usually nominal for the government, at least. It's usually around $100, and it's to process things like additional samples that you have to submit, or a filing that is sort of ancillary to the actual application. Like if there is a scenario where the ownership of the mark changes hands, or something, or an assignment is required from like a foreign entity or something like that, you will have to submit maybe a separate form outside of the process that you began for the actual registration of the trademark, and there will be fees attached to that, and it will be required for you to submit that application, submit that form as part of your response to the examining attorney. But they'll let you know, if additional filings are required, and if there will be fees associated with them. But typically typically not. If you need to just disclaim a couple of words in the phrase that you're seeking to register for trademark, uh, in that scenario, you will not be charged an additional fee.
Right. Well, that was it for the questions about office actions. Is there anything else that you wanted to add that we didn't get to?
No, I think we covered it. I think that the team did a great job of setting up this conversation, and I think that you did a great job of moderating it and pushing it along, Michelle. And I just want to encourage everyone to talk with an attorney if you have any questions about the trademark process, because this is the USPTO does attempt to provide guidance through their website, but it is a absolutely an unbearable amount of information to attempt to absorb in a single sitting, especially if you're working, especially if you have a business that you're trying to run. This is going to be a lot of information to attempt to absorb all at once, and it is going to be a process that you're going to be moving into with some uncertainty. Better to have somebody who's been through this before. It's better to have somebody who is trained to understand this process by your side. So my only advice is talk to an attorney, and if possible, talk to an attorney before you file your application.
Yeah, on that note, speaking of questions about the trademark process, we do have a couple of questions from the comments section as we're going here. These two questions come from Dan. I think we just talked about the first one really quick. Thank you, Dan, for writing. The first one, would you say pro se applicants or applicants applying by themselves are more likely to be confused by a trademark application office action? From what we've seen and from what we've talked about, I believe the answer is yes.
Yes.
Without like Michael was saying, the USPTO website, it has a lot of information, but it's not always the most helpful information or the easiest to absorb if you don't know exactly what you're looking for. The second question, what's your opinion on the cost-benefit analysis of ordering a search prior to filing an application as opposed to just filing the application? The costs are usually pretty similar.
Oh,
We
interesting.
touched on this a little bit. What do you think?
What do you think, Michael? That second question is interesting.
The cost-benefit analysis of just going into the process without having done a knockout search or some sort of a comprehensive search. I mean, how badly do you want this mark registered? Like how much? Like do you want this trademark or not? Do you really do want to go in with as much information as possible, and with as we said before, an understanding of what the lay of the land is going to be like when you start your application. You want to know where that elephant is going to be in the road and at what times, and if possible, how you can get around him. And that strategy begins with a comprehensive search, which you would perform before you even file before you even begin your application with the USPTO.
Yeah. And I would add to that, I think of, that's totally right. And I also think of the cost-benefit analysis. Sometimes it's a one-point inquiry when you're just thinking about cost, right? So we charge $689 for a comprehensive search and then $1,100 plus government fees for the application. So if you're thinking, I could just go for it. Do $1,100 for the application, see whether that works out, and then if that doesn't work out, I would start over with my new trademark application. Here's the deal, though. That's the cost analysis, which I still think the cost is worth it. But then you also have the time and the energy involved. And Michael, in your experience, how long does it take to get a trademark from application to registration?
Oh, it's usually about 8 months.
8 months, and like sometimes a year to go from application to registration. And this is your business name. So in terms of if you're just starting a business, and you want to protect this business name that you have, I think it's just so often the case that you don't want to invest in your website, in your business cards, in maybe the sign for your storefront, the packaging for the products that you're providing. All of that stuff is based on the name of your business and making sure that you have the rights to use this name. And just to know your chances as soon as possible is so important.
Right. And it'll usually take about 2 to 3 months to get it off, to even have your application assigned to an examining attorney, and then it can be another month or two before they send you an office response. So that is potentially 5 months wasted, that you could have been in, the full stream of, that's 5 months that you could have had, where you would be that much farther along in the registration process, but instead you're finding out after 5 months, oh, this isn't viable. I'm going to have to start over. And that doesn't even include the investment that you've made in your company and in that name in that 5 months in preparation for the registration that
Yeah.
you were anticipating. Yeah.
We're also always dealing with the emotional component, which Rebecca and I were talking about at the last live stream. Sometimes naming your business feels kind of like naming your baby, and it's hard to let go of the name.
Mm-hmm.
So the sooner you can come to terms with it, if you have to do it, the better.
Absolutely.
Well, thank you both. Dan, I hope that helped answer your questions. Thank you for asking. If anybody else has any other questions, feel free, pop them in the comments. We'll see them. Or you can shoot us a message. We'll get in touch about that. Shoot us an email. Visit our website. Follow us on Facebook. Sign up for our newsletter. All of the things. We have lots of things, and they're all for you.
Lots of ways to reach out. And thanks for being here, Michael. It was so great to have you, and we're so excited to have you now as of counsel on the G&G Law team to help clients with the trademark process. And you did great.
Absolutely.
You're full of trademark information.
Thank you. It's something that I really enjoy, so I'm happy to share my knowledge.
Well, we're glad to have you. Well, thank you all for watching. Tune in next time. We'll let you know when that is. And in the meantime, stay healthy, stay safe, and have a wonderful weekend.